The United States has a fairly strong history of union and labor rights. Let's take a look. Workers in the United States enjoy more rights and freedoms than do workers in many other countries, including the right to form and become members of unions. However, over the past 40 years, union membership has declined and continues to do so. In 2016, only 10.7% of American workers, approximately 14.6 million, were union members. Therefore, most businesses do not have unions as part of their HR process. People join unions for a variety of reasons, including increasing pay and benefits, especially good healthcare coverage and retirement plans. There are certainly both good and bad components to unions and unionization of organizational workforces. On the positive side, unions are tasked with providing their members with jobs in which they are provided fair wages and good benefits, as well as protecting them from arbitrary disciplinary and other actions by employers. On the negative side, unions frequently drive up employer costs, provide subpar employees, and may disrupt organizational work through strikes and other stoppages. Let's take a look at unions and their impact on organizations. The most predominant unions are those whose members are public sector employees, such as teachers and police officers. Labor union membership in the private sector has decreased dramatically in the last 40 years in the United States, to the point where only about 6.4% of private sector U.S. workforce belongs to unions. Public sector unions have also been on the decline, with legal changes in some states having significantly cut their membership. When Wisconsin passed a law in 2012 making public sector union membership optional, membership in AFSCME, one of the largest public sector unions in the state, dropped by 45%. However, some experts believe that union organizing is beginning to increase. If employees decide they want to join a union, what steps do they take? Usually, the employees will go through a union organizing process. In this process, employees will select a union to represent them and then ask for a vote of employees concerning whether or not they desire to be represented by that union. The primary method for union elections is a secret ballot. The NLRA, discussed in other presentations, gives employees the right to bargain collectively with their employer and to choose a union as their representative. The NLRA is the primary federal law governing union organizing and elections in private firms. An election is authorized if at least 30% of employees in appropriate bargaining unit sign authorization cards allowing the union to negotiate employment terms and conditions on the employee's behalf. The union then presents these cards to the NLRB as an election petition. Once this happens, the NLRB sharply limits what management can say and do without being accused of an unfair labor practice. A combination of strongly pro-labor NLRB rulings and mandates has recently made it much easier to organize new bargaining units. One decision that's caused significant concern for organizations is micro-bargaining unit decisions that are recently shaped via the NLRB versus FedEx Freight Incorporated, in which the Third U.S. Circuit Court allowed a small part of an employer's workforce to be constituted as a bargaining unit. The NLRB has noted that these units would be presumably appropriate unless other employees share an overwhelming community of interests. There's some evidence that union organizers win more often with smaller groups of employees voting, so this ruling could lead to stronger unionization efforts in small groups. The concern is that this micro-unit bargaining could lead to companies having to deal with several different union contracts within one organization. This could create an untenable situation due to the time and cost of bargaining with multiple unions per year. The NLRB has also agreed on a quickie election rule that allows union votes within 10 to 21 days of the date of the petition for election. The previous average time between the election petition and the vote was an average of about 38 days. What this does is limits the company's ability to provide union employees with information that would be favorable to the organization before the vote is held. This rule is often referred to as an ambush election rule because employees feel like they're being ambushed without the opportunity to defend their current employment arrangement. Be aware, though, that current efforts in the U.S. Congress could undo this ambush election rule. If these are successful, companies will have more time to respond to union organizing efforts.